lies, injuries, and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb, the attorneys answer your tough legal questions straight ahead.
Hello and welcome into the attorneys. Hope you are doing well on this Sunday evening. We appreciate you being with us tonight. As is always the case, we love to hear from you. So from now all through the next 30 minutes, you're going to have an opportunity to get your questions to us, and we will present them to our panel of experts today. The numbers for you to call, text, email, right there on our screen. And we're joined again by Josh Wright of the firm Hollis, Wright & Couch. Good to see you, sir.
You too. Hope you had a good week.
It was indeed. Thank you so much. We were talking, today about jobs, but not just the job place, but whenever injuries take place on the job.
1.5 million individuals in Alabama are employed. At least their families have somebody that's employed. Mm-hmm. So workers' comp impacts and affects many, many people.
Right.
When we have these types of issues come up at our law firm, which happens often in the type of cases that we have where somebody will be injured on the job and we may have a civil case for them, we go to the comp expert, and the comp expert in the city of Birmingham, as far as I'm concerned, is Allwin Horn. And we bring Allwin in to answer questions for us and to work with our firm, and he does a great job, and we're just excited to have you here with us today to answer some questions.
Well, Josh, I appreciate those kind remarks, and thank you again for letting me be here, David. Yeah. I appreciate y'all letting me be here with you tonight.
We appreciate your time, and I always like to start with an overview. How does the Birmingham area and Alabama as a state, how do we do and how do we rank when it comes to personal injuries on the job and those sort of issues?
The Alabama Workers' Compensation Statute, if you want to rank it compared to other states across the country, needs some improvement for the employee. Mm-hmm. The act was originally created to benefit the employee, and there are some benefits to that in that the employee, whether they're at fault or not for their own injury, they're going to be guaranteed some compensation while they're unable to work. They're going to be guaranteed some compensation, some benefits for any permanent injuries they sustain, and they're going to be guaranteed medical treatment during the course of their injury, and then for the rest of their life if that injury is permanent and needs more treatment. So that's the benefit to the act. Some problems with the act is that there are some caps that apply in terms of how much the benefits are that are awarded to the employees. Right. And right now Alabama ranks very low in terms of the amount of the benefits to be paid, comparatively speaking, to other states.
Alabama's Comp Act is also a no-fault act, which I think dovetails with what Allwin was saying, allows for an individual, regardless of who caused an accident, to be compensated for the injury. And that's unique to law in general in Alabama because fault is relevant and pertinent to all other forms of civil litigation. So it's a unique statute for sure.
And that's exactly right. Josh hit the nail on the head. It's somewhat a trade-off between employers and employees. Employees are guaranteed benefits. They're going to get something. They're going to get their medicals taken care of for life, but at the same time, those benefits may be low and may not be equal to what they were making while working. Mm-hmm. And at the same time, I guess the benefit to the employer is that they can't be sued for negligence and be hit for what some people would say would be large sums of money.
Oh, and I know a lot of people, you and I talk with these folks on a daily basis and weekly basis, will sometimes act as if they're going to be able to handle a comp case on their own. But explain just kind of and give some context to people why it's a good idea to get a lawyer and how low the fees are and why it's important to have somebody that kind of leads, guides, and directs you through the process.
I appreciate that, Josh, and that's a good starting point. The Workers' Compensation Act, it's a statute in and of itself, and there's so many different areas that someone needs to be familiar with, and the average individual, even a lot of lawyers that practice in the area, it can be complicated. You're entitled to different types of benefits, whether they're permanent, they're temporary, they're partial, you're entitled to medical benefits. It's always best to go to an attorney that knows what your rights are under the act, what you're entitled to. A lot of times employers are either unfamiliar with the act or either they just don't want the claim to be reported to their insurance company, so they may mislead you. It's very important to immediately report the act. You have 5 days by statute to report that act to your employer. It can be drawn out with exception, but the best thing to do is to immediately report that. There are requirements of what doctor you can and cannot see. If you want your medical bills paid for under the Workers' Compensation Act, you're going to have to go to a doctor that the employer or their insurance carrier has selected. And that is one of the most troublesome things with the Act, in that if you go to a doctor on your own, the workers' compensation carrier is going to have to pay for it, and you're going to be stuck with a big bill. Yeah. And then again, if you have personal health insurance, they're not going to pay for it because it's an on-the-job injury and should be covered by the workers' compensation insurance carrier.
Yeah. Okay. We love your questions. On your screen right now, you'll see a way for you to call, text, or email your question to us. Let's go to our first question of the day. I hurt my leg while doing my job, gave the doctor's bill to my boss, who told me that I have to pay because he doesn't carry workers' compensation insurance. I thought all employees had to have workers' comp. Is this right?
Well, the requirement under the Act is if an employer has 5 or more employees in the state of Alabama, they are required to have workers' compensation insurance coverage, or either pay into a self-insurance fund to protect these employees they have. There are some exceptions in regards to the agriculture industry, but for the most part, any employer that has more than 5 employees is required to have insurance coverage. If they don't, then it can be a double penalty to the employer for benefits and medical expenses.
And explain that. Is it a double penalty that goes and inures to the benefit of the employee that was injured?
It does inure to the benefit of the employee.
Okay.
So if someone was to receive, just as hypothetically, $15 per week for a payment, they would get $30 if there was no insurance in place.
Okay. So in this scenario, if this employee was told that and they come to you, then you all kind of take it over from there.
I'd look up, I'd go to the internet, look up the company. You can find the size of the company anywhere. You can ask the employee how many people are employed there, and you're going to know better. You're going to send a letter out to the company itself, and find out who their insurance company is, and start your relationship with the insurance company. You're going to want to make sure the temporary disability benefits are started. Those benefits, that's an individual that is injured on the job and the injury prevents them from going back to work for a period of time while they're being treated, is entitled to 2/3 of their average weekly wage while they are out and unable to work, being treated by a doctor or otherwise. So we want to make sure those benefits are started. You're not sitting at home unable to help your family out, and you can pay your bills. At least you have that coming in. And then, of course, we want to go ahead and get you to a doctor that's authorized so your medical bills are taken care of.
With the right lawyer, David, this process can start very, very quickly. We oftentimes see individuals that are trying to get through the disability process who have been badly injured in an accident, for example, or individuals who are trying to get some type of insurance, supplemental insurance they may have cranked up, and there's a 90-day grace period before they can even get it. Comp is, with a lawyer especially, to work very, very quick and very efficient.
And let me add on to that, Josh, because it's a good point. In any type of claim you have, you want to give the proper parties notice immediately and start moving forward with preparing your case, because witnesses disappear, facts can change depending on who you talk to, and you want to go ahead and put something in writing and get moving so people know that there was an injury.
Okay. Another question from one of our viewers. My job requires a lot of heavy lifting. After I finished one of my shifts last week, my back and legs started hurting the next morning to the point that I could not stand. I still have a hard time moving. My job's insurance company told me that they wouldn't send me to a doctor because my injury was not payable under workman's comp.
That would be a position taken oftentimes by insurance companies or employers. A lot of times people have, and I'm just taking on this question and this hypothetical, a lot of times people have what's called a pre-existing condition. I mean, as we age, everybody's back gets worse with time. It becomes degenerative, is what they call it, a degenerative condition in the spine. You're just not as good as you were when you were young. People may have pre-existing conditions that become aggravated on the job. For example, lifting aggravated the pre-existing condition, but the aggravation of that condition is compensable, because an employer takes an employee as they come through the door. I may have been injured in the past in a certain area, but it doesn't prevent me from doing my job.
Right.
Now, once I get on the job and I'm injured during the scope and course of my employment, and I aggravate that same condition that prevents me from working, it is a compensable injury.
Okay. Ultimately, I think one of the things that person needs to know is, if you can prove that your injury was arising out of and in the course of your employment, you've got an argument to start as kind of the foundation that there is a comp claim there. If the employer is able to substantiate you were not injured arising out of and in the course of your employment, That's kind of a preliminary issue that ends it.
That's the standard or the burden of proof is that if you are injured, whether it's an aggravation or a new injury, if there's a medical connection to that injury and to your job, then it is covered under the Workers' Compensation Act, as long as you were performing a duty within the line and scope of your employment.
All right, time for our first break. As we do so, want to remind you, we'd love to hear from you, getting some good questions tonight. Waiting for yours as well. You can call the number there, text us, or email us at that email address. Also find the firm at Facebook. You'll find them, just search Hollis, Wright & Couch, and also on Twitter, Hollis_Wright. Coming up after the break, a question about hearing loss on the job. What sort of options do they have? We'll find out from our experts right after this quick break.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Welcome back into The Attorneys. A reminder, a couple of segments left for you to get your question to our panel of experts. You can text, call, or email that question to us, a question that we've received oftentimes, a lot of plants and factories nearby. This is probably something that you've heard before, Allwin, but this question from a viewer: I work in a factory that is very loud. I've noticed that I cannot hear as well as I did last year. Others who work with me tell me the same has happened to them. Is this a case?
It absolutely can be, and most likely is. There are a few different type of compensable injuries, or injuries that are compensable in the Workers' Compensation Act. You have traumatic injuries, for example, you get your foot run over by a forklift, or another injury that immediately happens. You can have occupational diseases, is where I would classify this or categorize this.
Okay.
An occupational disease arises when someone is engaged in a job and their job exposes them to something peculiar that the everyday workforce isn't exposed to.
Yeah.
Loud noise would be what would be peculiar in this situation. You have people that work in fiberglass plants, who deal in coal mines, who work in coal mines, and they are exposed to circumstances and conditions that normal people aren't in their everyday workforce. And that's considered an occupational disease, and as long as a doctor connects the dots saying that these conditions caused this injury or illness, then it will be covered under the Alabama Workers' Compensation Act.
Another example would be chemicals, exposure to
Absolutely.
chemicals that you and I are not exposed to on a daily basis.
Okay.
Absolutely. And another category of injuries covered is what's referred to as cumulative stress injuries. People that do repetitive motions in their job, for example, typists, sewing factories, carpal tunnel syndrome, cumulative stress to certain parts of the body that's repetitive in nature daily, that is peculiar or different than the ordinary workforce would be exposed to.
And I think Allwin put it in good context, but you've got to have a doctor in those cases that ties the causal connection, if you will, between the exposure and an on-the-job injury. In order for it to be compensable and for you to be able to argue under the compact, you're entitled to some form of compensation. Another good shining example of why you would want to go to a lawyer that understands these cases, knows how to navigate the statute, and knows the questions to ask the doctors under deposition to make sure that the doctor does, in fact, tie all the connection together to make sure that you have a compensable injury.
And
Very important.
Let me add to that, if I can. In a nutshell, you have two burdens to prove. You have legal causation. The injury occurred during the line, scope, and course of the employment Employee can testify to that. Witnesses can testify to that. It happened. And then you have to prove medical causation. And that is having a medical professional testify that the incident or the conditions caused the injury itself, legal and medical causation.
All right. Another question from our audience. This is a recent event. I was hurt on Friday afternoon at work, taken straight to the doctor by my coworker. What should I do next?
You should immediately report the accident to a supervisor or an upper managerial person. So a first report of injury is created and the incident is reported. That way it can be forwarded to the insurance company. You want to make sure the doctor you are taken to is a workers' compensation or employer approved doctor. That, like we previously mentioned, the employer has the choice of doctors or the insurance company gets to choose the doctors. There are exceptions to that, and I think we'll cover that, referred to as a panel of 4. If you ever become dissatisfied with a treating physician, you're entitled to a selection from a new panel, but again, provided by the employer or the insurance company. Those are the first 2 things I would make sure you do, is report it to the proper persons, and meaning provide notice, and make sure you get to an authorized doctor.
Are there some doctors, Allwin, that are considered, I guess, if you will, oriented more towards the employer than the employee? Is that something you see, or are they fairly objective all the time?
Well, I mean, that's a case by case. You know, you have to use a case by case analysis. There are people in every faction of the world that are going to have biases. So sure, you're going to come across doctors that might get 85 or 90% of their business from referrals from industry or from a certain business or insurance company. And then you have doctors that see a broad span of patients from those walking down the street, not related to job injuries, to car accidents, to those just with common day illnesses. I think that's just a case-by-case analysis, but of course there are doctors that are preferred by the employer or insurance company.
Another reason why this panel of 4 that you can request through counsel, you could do it on your own through the statute, but through counsel, another example of why you have that, in order to make sure that you're able to get to a doctor you're comfortable with as a patient, that is an objective doctor that's going to be handling your injury.
Good clarification there, Josh. The point of the panel of 4 is if an employee is dissatisfied with the treatment they are receiving or even the opinions they are getting from a given doctor, say the doctor selected by the employer or the employee, they can say, I'm dissatisfied under a certain section of the compact, give me a panel of 4 physicians in the same field, same specialty, and I get to choose one. Now the thing is, once you do that, that is your physician, and there's no going back.
All right. Another question from a viewer: what all am I supposed to get under workman's compensation?
First of all, let's just start from the beginning. You're injured. You have to come out of work because your injury prevents you from going back. You're entitled to what's called temporary total disability benefits. If you're unable to return to work during the healing process, you're entitled to 2/3 of your average weekly wage. Now, there are certain caps that apply. Sometimes when you have real high wage earners, they're not going to get 2/3 of their average weekly wage because the cap's set lower than that. That's another thing that needs to be changed in the state of Alabama. You are also, let's say you can go back to work, but they put you at a light duty job that doesn't pay as much as your pre-injury job. Then you would be entitled to temporary partial disability benefits, which would be the difference in what you're getting paid on light duty and what you are making. Then once you're placed at what we call in the workers' compensation field maximum medical improvement, referred to as an MMI, you will be assigned a permanent partial impairment rating, some impairment rating to your body. You may have a vocational loss if you're unable to return to your pre-injury job and can't go back to that field, or you may be permanently totally disabled. And for each one of those, there's a different way to calculate what someone's entitled to.
Okay. Once again, shining example of why you go to a guy like Allwin. You got to understand the statute to be able to navigate it successfully, and trying to do it on your own, tough decision. And the fee is fairly low in cases, and it's fixed.
I should have pointed that out earlier. Some of the benefits, at least to the employees and the act, is the fee is a maximum of 15% of the recovery. That's by law. That's all the attorney is entitled to. And I'll tell you this: if you have a question, don't try to handle it on your own. Call an attorney, because they're going to answer your questions, or they should, at least for free, in a consultation.
Okay. All right. A question here, a pretty long question, but the gist of it: an employer referred me to a doctor for my injuries. An employer did that. Not really pleased with the doctor that they were referred to. Can they switch doctors?
Well, this goes back somewhat to what we were just talking about in the panel before. The employer cannot, once they assign you to a doctor, cannot just switch you to another doctor. Now, they do have the right, the employer, the insurance company does have the right to what's called peer review.
Right.
A lot of these companies, insurance companies, they have doctors on retainer in different states that they will send the medical records, your medical records as an injured employee to. This doctor doesn't even meet you, but by just looking at your medical records, they're going to give an opinion that the treatment you need is not medically necessary, nor is it reasonable.
Right.
And I mean, there are ways to fight that, and you do fight it. Okay. And you file a motion, you get the court to order the treatment, because a lot of times judges frown down on this peer review by a doctor that doesn't even see this patient, right. And will side with the patient. So in a nutshell, they'll try to do it, but the law will eventually, in my opinion, side with the employee.
So in this case, the employee not pleased with the doctor, there is an option, and they could get it.
The employee can use the panel of 4. Say, I'm dissatisfied with my doctor. I want 4 doctors similarly situated or in the same field or profession or specialty, and can choose. Now, a lot of times, what I was referring to is the employer, if they aren't liking how things are going or the treatment the doctor's recommending, because it may cost too much, or they want to do something more conservative at an earlier stage, they'll go hire somebody to say it's not necessary.
All right. Okay. Time for our second break. One more segment of the attorneys set to come as we head to break. A reminder, you can still get in touch with us. Time to do that. Call, text, email your questions to us. Also find the firm of Hollis, Wright & Couch on Facebook as well as Twitter, Hollis_Wright. Stay with us. We are coming right back.
From all of us at Hollis, Wright & Couch, we're proud to team up with Alabama's 13 to present the attorneys each Sunday night. Our goal, to answer your tough questions and provide legal support when you need it most. Remember, you can call, text, or email us your legal questions anytime. This week's topic relates to injuries on the job and Alabama's workers' compensation laws. Here are a few facts you need to know. An employer is financially responsible for an on-the-job injury. Legally, they must pay for all medical treatment related to that particular injury at the time of the accident and into the future. If you're unable to work after an on-the-job injury, you should be entitled to receive temporary disability benefits. These benefits should amount to about 2/3 of what you were earning before the accident. Even if a doctor allows you to work part-time or to perform other duties that pay less than what you were making, you're still entitled to temporary partial benefits. You need to find an attorney experienced in handling workers' compensation claims. They should fully understand the Alabama Workers' Compensation Act and be able to explain it to you, including the differences in litigating work-related injury cases versus other personal injury matters. The sooner an accident can be investigated, the better chance an attorney can gather all the important information necessary to handle the case. If you have an idea for our next show topic, please let us know. Please also remember your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. We can't guarantee that we'll answer every question during the show, but we can guarantee a competent lawyer will respond to every question you send in. Thanks for watching The Attorneys here on Alabama's NBC 13.
Welcome back into our final segment of the attorneys. We appreciate you being with us today. We not much time left, so a couple of questions I want to try to get to before we wrap up the show. A question here: what can I do about earning money for my family if I can't go back to my old job because of my injury?
That's a very good question. And it goes back into one of the different categories of benefits you're entitled to as an injured employee. If you are unable to return to your pre-injury job, then you are entitled to what's referred to as vocational benefits, vocational retraining. That is, your employer can be required to retrain you, to reintroduce you to a new profession in the job market. Vocational loss is loss of access to the job market. A lot of times people who have been heavy industrial workers, machine operators, been miners all their life, they know no other trade. Right. What you have to take into consideration in determining what a vocational loss is someone's skills, their past job experience, their educational level, and their ability to be retrained. And a lot of times people, depending on the severity of their injury, can't be retrained to do anything. Someone that's done heavy work all their life can't go become do a sedentary job as a bookkeeper. Yeah. If that's the case, then you may be unable to be vocationally retrained. You may be entitled to a permanent total award in your case and receive benefits for the rest of your life. Otherwise, you can be retrained to do another job, or you can get benefits that exceed a permanent impairment rating, which is another classification of benefits to an employee.
Okay. All right, we just have 1 minute left, so time for a final thought from you, Hollis?
My final thought would be that as much as employees that are injured on the job want to please their employer, and I know they may have good relationships with them, you need to take care of yourself, and it's always wise to contact an attorney, even just to talk to them if for no other reason, and get advice. And here's what I want to say. While you think your employer is the one that you're actually suing, most of the time, 95% of the time, it's an insurance company that's paying the bills and that's responsible for paying for that. And they're in the business of making money, and they want to save their money, so look out for yourself.
All right. The only thing I'd say is the reason Allwin and I have such a good working relationship when he does comp with our firm, a lot of times Allwin will see things that are in addition to comp. Just because somebody has a comp claim doesn't mean they don't have another claim, like a product liability defect that caused an injury, or, for example, an industrial accident. He'll come to us, and so you want to make sure you get to a lawyer that can evaluate the entire picture itself to see what claims are out there.
Sounds good. Gentlemen, thanks so much. That's going to do it for us. We appreciate you being with us. Check out the firm. Plenty of ways to find them. We'll look to see you next week.